The 2013 Housing Act was moved by the Chief Minister in Parliament. The then Housing Minister abstained from voting on it because, in Fabian Picardo's words, he lived in an affected hereditaments. The effect of the Act was to control rent in dwellings built between 1945 and 1959, the tenancies for which had been agreed before 2008. The law affected tenancies in Matilda Francis building in the South District, and the landlords challenged it in court. However, Justice Karen Prescott dismissed the claim on the grounds that it was part of the ebb and flow of rent control provisions, which had advantages and disadvantages on both sides. The challenge then came before the appeal judges, Dame Janet Smith, Sir Colin Rimmer, and the Chief Justice Anthony Dudley, who concluded that the Act interfered with the landlord's constitutional right to the enjoyment of their properties, namely the rents and value of the building. They observed that the rents of 23 of the 41 apartments in the building were reduced from £500 to between £100 and £150. The judges said that neither the Chief Minister in Parliament nor the government's lawyers had explained what the underlying objective for this law was or why it was important, and believed that if there was any public interest in it, it was very slight. They observed that the second reading of the bill was carried unanimously in Parliament without any discussion of the merits or policy behind it. In their judgment, they said it was worrying that one of the limited class of people who could potentially benefit from this windfall was the then Minister for Housing, Paul Valvan. They said it was even more worrying that the Act was passed against the background of a dispute between the landlords and the tenants about the levels of rent the landlords were asking for. In answers to questions from GBC, the Chief Minister said the decision to promote the Act was made by the Cabinet as a whole without Paul Valvan's involvement, as he declared a short-term interest in the decision. He said the Cabinet did consider that a good social policy reason arises for the legislation and is considering appealing the decision of the court. The government says it stands by its decision to promote this Act to protect tenants from the rent increases desired by landlords, and points out that Minister Valvan is not a beneficiary of the relevant decision.